Yo, what's good, everybody, man? Cirilo in the building, man. And joined by my man CJ here. We're gonna do some analysis really quickly. If y'all just seen yesterday, a lot of people have seen at this point. Derek Chauvin, attorney Eric Nelson filed a motion for a new trial based on the grounds of jury misconduct. So what we're gonna do is kind of color or contextualize what's really happening. And this is really powerful, of course. We want to work through different scenarios, what could happen, to kind of put folks at ease about what is the reality of the recent news around the Derek Chauvin trial. So anyway, with that being said, man, CJ, man, how you doing today, brother?
I'm doing good, brother. I'm doing good, man. Feeling real good. How about yourself?
Man, I can't complain, dog. I think that I remember when I saw the announcement, right? And I was like, yo, what is Buddy really trying to like, do? I mean, for me, and I know the same for you, I was like, oh, this is par for the course. This is just what attorneys do, in terms of advocating for their client. And so I want you really quickly to kind of walk through for folks out there, that are like, how could Eric Nelson file for, motion for new trial? Are there really grounds for that? And so, really quickly, man, as an attorney, as somebody who has gone through the process of advocating for the client, even actually actually filing motions such as for new trials, judgment notwithstanding the verdict, and so on and so forth, man. What are some of the particulars around post trial type of like actions?
Absolutely. Before we get started, really quickly, for those who have eyes on this right now, please share this with your audiences because this is a really important as far as just giving people peace of mind with regard to what's happening in this ongoing seem like never ending trial or never ending saga that is the Derek Chauvin's murder of George Floyd. Uh, just wanted to say that before we got started. But I'm glad that you asked that, Rillo, and I'm glad that you encouraged this conversation because what we're seeing in this particular case with the motion for new trial is actually something that I would say is par for the course when it comes to uh, just the trial process. Uh, After a conviction or after the adjudication of a matter, in the event of a conviction, it is not uncommon for a defense attorney to file a judgment, a motion for a judgment, notwithstanding the verdict, meaning uh, asking the judge to basically look at it and say, "Hey, the jury, they didn't know what they were looking at. They didn't understand for them, what they saw or were unable to process and assess this. We're asking for the judge to make an independent decision on a motion. Usually those get denied. And motions for new trials also happen. And these are two things that are common that are filed prior to an appeal, right? Prior to having to move on to the appeal process, and typically denied. But there are things that are standard or par for the course as it relates to.
Yeah, man. So, to folks out there, what y'all gathering, I guess in a nutshell, simply put, Derek Chauvin ain't getting out of jail, man.
Yeah,
Something,
exactly.
some type of, I mean, literally, you would have to be abducted from aliens inside the jail, right? I mean, I'm only saying that because the attorney threw out some alien type of deal, some superseding event, and try to make some type of plausible connection between what happened, and why Derek Chauvin had the knee on the back of George Floyd's neck for 9 minutes or so, and some trying to make some type of alien, comparison or analogy, or some superseding event, that would have caused him to kind of be distracted, if you will. But nah, man, I think that, like, you know, obviously this trial has been documented more times than folks would like. And I think, like you said, the point being made is that this is just what any competent attorney would do, and this is par for the course. But I still want to run through, like, what if, let's play what if, right? What if Derek Chauvin would be running a new trial? Um, what if witnesses didn't show back up for the trial? I mean, even from that standpoint, right? will the records from the previous trial be able to be used in a new trial?
Absolutely. So I'm glad that you asked that question, Rilo, because a juror could not suddenly get on the stand in a new trial and have a totally different testimony than they had in their previous trial. What would come in is their prior consistent or prior inconsistent statement or testimony from their new trial, and that's something that could be used whether they are present or whether they aren't present, and it can be used for two purposes. It can either be used as a previous recorded recollection, or to refresh one's recollection, right? So the way that it comes in substantively, which means as a matter of the law, or which means that it comes in on the record and as a part of the record, um, is in the event that a witness is unavailable to testify, um, their testimony can be brought in from the previous trial and placed into the record as a part of the evidentiary transcript, the evidentiary record, uh, as testimony that is consistent, sworn testimony at the previous trial matter. So it can also be used in for impeachment purposes. When we say impeachment, when we talk about uh, trial hearings, what we're talking about really is in the event that somebody get their ass on the stand lying, right? And we like, why you lying? This is what you said last time. Now you're saying this. Now, when you lying then, why you lying now? And you would never that testimony. I don't anticipate any of the Floyd witnesses coming on the stand and doing anything different. But of course, what we could be asking is, would any of the defense's witnesses try to switch it up now that they've had an opportunity to go to school on the theory of the case or the strategy that was employed by the prosecution? And the reality is that they couldn't come in. The defense couldn't come in with suddenly a different theory of the case and a different defense than what they presented in the initial trial.
And even if they did though, right? What would be like would there be any other defense that they could come with outside the defense that was already in terms of the initial case in chief?
Uh the only defenses that they would really have available to them, I believe, is an affirmative defense, and it wouldn't even be a viable or a good defense. It would just be the only one that would even remotely make any sense. It would have to be an acknowledgement that yes, we did. Yes, Derek Chauvin did kill George Floyd. Yes, he was the but it would have to be yes but type of situation. Because with self defense, you got a yes but, right? But of course, we know this wasn't an issue of self defense. With insanity, you have a yes but. You know what I mean? Like yes, but I was either unable to control myself due to an irresistible impulse, or I was unable to appreciate or understand what I was doing at the time that it was happening, unable to perceive and unable to stop myself. Uh, it would have to literally be some type of circumstance that uh, is really unfathomable at this point in order to have a viable defense. But the problem with that is they've already gone on the record with their perspective with regard to what the defense to this trial is. And so, uh, you know, e- expanding the scope beyond that to try to justify it on other grounds, including an affirmative defense, would be counterintuitive, I think, at this point. It
Now
would.
something happened during that trial. It was objected by the prosecution when counsel Nelson, Eric Nelson, counsel for Derek Chauvin started to bring in the state of mind of
Mhm.
Derek Chauvin. It's almost as if like there was this moment in which he wished that Derek Chauvin maybe had testified. Do you think that if they were granted a new trial, that Derek Chauvin would then get on the stand and testify on his behalf, understanding that during closing arguments that could be a way in which he can speak to the mind of Derek Chauvin? I mean, I'm not saying that'll be enough. I'm just now thinking about the trial, knowing that we watched the whole thing. Would there be certain things that Eric Nelson would advise his client or Derek Chauvin may be open to doing, knowing that, hey, I'm gonna probably be guilty anyway. So
Mhm.
now I'm just gonna start trying any and everything to muddy the waters. I mean, what would kind of probably take place?
Well, yeah, they definitely certainly had already started doing that type of posturing even during the trial with some of the objections that they were raising about trying to get the jury to be sequestered, things of that nature. So he was attempting to preserve a record at that time for the purposes of trying to have some ground on which to appeal this case. Um, it was a it was a daft strategy, but it wasn't necessarily something that was going to be effective. As it relates to Derek Chauvin testifying, I think that that's something that he could do. I don't know that it would be any more effective than him not testifying because the video speaks for itself and the jurors could see the video from multiple angles repeatedly. They can hear the testimony of those other witnesses. And it would be very difficult uh, for Derek Chauvin, especially on the grounds that whether it was knowing, whether it was intentional, whether it was unintentional, uh, he was convicted on all three grounds. Like they didn't, his mental state, even though mental state was the thing that shifts one from one type of homicide to the other, they basically decided that look, whatever his mental state was, whether he was reckless, whether he
You
was no,
guilty. You
whether he
I
was,
don't give a damn. You
he was
guilty.
intentional on all three grounds, right?
You
So
guilty, dog.
yeah,
We not even we don't even want to hit none of that. We don't even give a damn. You was reckless if you knew it or not. Hey, bruh. Hey, you knew when you handcuffed that brother. You knew when you put your knee to his neck that there's a possibility he could strangle to death. And then you knew at some point though that was reckless, or according to
yeah,
way the law facts, or when you align them up. And to me, it was one of those things where I think it's just honestly undeniable, kind of irrefutable
yeah,
evidence. Hey man, what's up, bro? Boy, I see you over there. Man, but it was just undeniable, man. And
yeah,
but since we here, right? I love doing these like what ifs because I feel like this brings us back to law school. Like, what if this happened and what if that happened, and trying to look at everything from every angle. So let's say Derek Chauvin says, you know what, man, Eric Nelson, you were an incompetent attorney. You didn't represent me with fervor. You didn't represent me. You didn't file the correct motions. You didn't do this. You didn't raise these issues at trial. You didn't raise these defenses at trial. And because of that, man, I render you in my mind. I want to get more outside counsel to say that you were incompetent at the time of the trial, throughout the duration of the trial, before the trial, which is why I'm actually guilty. And I'm
mhm,
not guilty because I had my knee on his brother's neck for 9 minutes and some more seconds. I'm
mhm,
guilty because you're incompetent. Okay,
mhm.
so let's say a court goes, you know what? Eric Nelson would be incompetent. What's the other hurdle that that Derek Chauvin would have to leap over in order to say, you know what though, I deserve a new trial?
Right. So the threshold, if the performance considered deficient uh, by the defense attorney, the other threshold would basically be that Jerry Sharma would need to be able to show that there was a reasonable probability that that if not for ineffective counsel, his end result would have been different. Basically, he would have to show that these 12 people that decided on 3 different counts that he was guilty of murder, in the second degree, murder in the third degree, and, manslaughter in the third degree, I believe, um, that if not for his counsel, he would have gotten off on all of those.
All
But
three.
yeah, but he had 12 jurors 12 people decided that he was guilty of those things based on
Uh,
the evidence that was presented to them. So it would be a very difficult threshold to overcome. In addition to that, he probably likely had to sign off on some documents saying that he was satisfied with his counsel at some point uh, during the during the during the trial and probably prior to the sentencing. He'll have to sign off on something stating as much. There were times during the trial where you saw the judge asking him questions about what he wanted to do and whether he was I believe whether he was pleased with the advice that he was given via his counsel. I believe there were times when and those safeguards are put in place particularly for that purpose. of attempting to ensure that those things are preserved on the record in the event that someone then tries to um, use that as a play on a post conviction type of relief or anything like that. So
Now, bro, I want to talk about this brother that went to the, the motion filed on the grounds of jury misconduct, right? Before we get into what the brother allegedly did or would have led Eric Nelson to filing such a motion on the grounds of jury misconduct, generally speaking, what is jury misconduct?
mhm. Okay, so basically, as at the beginning of the trial, if people remember, I don't know if everybody was watching it before the trial even began. You had jury selection process, and typically with the jury selection process, they ask you a battery of questions to which you are. It's called a voir dire, which means to tell the truth. It's French for to tell the truth, and basically what they're asking you to do is tell the truth about who you are and what you think about things, so they can try to determine whether implicit or explicit biases exist, so that they can either challenge a juror's sitting on the bench, either I mean sitting on the panel, either through a peremptory challenge or a challenge for cause. uh, and what I would imagine that they're trying to state is that they would have challenged for cause with regard to this particular juror. I think he was juror number 51.
For a state
Uh,
of mind, right?
right, with regard to his
Yeah.
state of mind. But I think that where they're gonna have difficulty is that uh it'd be virtually impossible. They asked everyone if they were familiar with Black Lives Matter, they had an opinion about it, so on and so forth. And based on what I've read, the juror answered honestly. He was asked if he ever attended any protests before. The juror said no. In my estimation, he did not attend a protest when he attended the anniversary of the March on Washington. And that, to me, that was not a protest. It was not a demonstration in the sense that marching in the streets in Minnesota would have been, or participating in the local demonstrations. Uh, Also, the March on Washington was something that was taking place prior to George Floyd ever being murdered. The March on Washington was planned. The March on Washington was happening. That was something that was in effect, and it was something that he was attending, regardless of. So the idea, it would almost be like asking someone had they ever have they ever heard the "I Have a Dream" speech, and have they ever supported Martin Luther King, right? And because they supported Martin Luther King, they are unfit to be a juror on a in a jury trial that that is revolving around a a a black man being killed by a white police officer. And the reality is that you ain't gonna find many people that aren't, at the very least familiar with Martin Luther King, and that may feel one way or the other about him, a multitude of ways. But that doesn't mean that they have the inability to sit on a
Be
jury,
impartial.
yeah, and to be
You know what I
impartial,
mean? To be
based-
impartial.
right, based on the facts that were presented before them. Uh, and 11 other people made the same decision. You know, to my knowledge, he wasn't the jury foreman. He wasn't the person that influenced everybody else either. So,
And let's be real here, though. We should also state there were 8 white jurors,
yeah,
right? There were
mhm,
only 4 people of color on that jury,
right,
and so there were 8 white jurors who believe the same thing. And
mhm,
CJ, you pointed out 50%, a little shade over 50% of people, Republicans at least, feel like Derek Chauvin received the short end of the stick, and that the jury got it wrong, that he was within his, like, I guess, police rights to use particular force, and they felt like it was reasonable in using said force, which brings up other issues about this country in terms of relationship between policing and black people, black communities, people of color in this country.
right.
uh, I
No,
guess,
that's
does that is that part of the energy behind it, thinking, well, there are other people out there that we can probably get a jury of other more peers that may be leaning more into the direction of favoring a Derek Chauvin, right? I mean, is that do you think that's part of the theory of what the Eric Nelson or counsel for Derek Chauvin is like thinking at this particular point?
Oh yeah, for sure. I think that I think that his hope is to get some more races on the jury. I mean, like it's like, damn, it's some good racists out there. Hey, like shit, let me see if we can get a few of them because like literally his whole defense was uh implicit bias. His whole defense was racism. Uh, your ability to see black people as dangerous or to see a crowd as dangerous when there was an actual act of violence taking place.
Right
Uh,
in front of them.
right in front of them, and that they were the dangerous ones. It was one person out there that killed somebody that day, but his attempt was to characterize everyone else as the dangerous people on that day. And the most dangerous thing you can do is kill somebody, right? So, I mean, like that's the complexity there, and I think that that would be the reasoning behind I want to do make this happen. But also, this was another reason why you know this is something that probably had a lot of people stressed out yesterday when they heard about it, bro. You know what I mean? Like the idea that motion for a new trial. We just saw that the man was killed, committed guilty on 3 different grounds. He hadn't even been sentenced yet. The motion, so people probably are feeling all types of emotions, and I think that's where it's important to highlight the importance of black media outlets like Black with No Chaser and what we're doing here because uh, we take into consideration the feeling of the people, the trauma, the feeling of the people, the trauma that's attached to reopening that wound so soon when we still trying to heal from it.
Yeah,
You know, just the, the unnerving way that it probably feels to hear um, this dude still might have a chance at
I get
you
it
know
out though. I mean,
right.
it's always a
Yeah.
chance. It may even though it be a snowball chance in hell, but there's always a chance. And
Mhm.
I think that the I guess lack of confidence of by black people towards the criminal justice system, and rightfully so, right? That this is there's a possibility, no matter how small of a possibility it may be, but it's still a shred of possibility that he can even wiggle his way into a new trial. Is and then having to relive, like you said, you pointed out just now, having to relive that moment again of having to wait on the verdict and be sitting on the edge of your chair and have to go through the testimony again, have to watch again, the video of Derek Chauvin having the knee on the back of George Floyd, and even thinking about it right now, the imagery of that is still like traumatizing. You know what I mean?
Right.
And
Absolutely.
but I do so it wasn't just about so part of the motion and what they point out a lot of the news point out jury misconduct because it was a brother they were pointing to, right? And that was the sensationalized portion of the news. But what they didn't say was is that the bulk of the actual complaint or the motion that was filed arguing for a new trial wasn't really just jury misconduct. That was a piece of it, but a lot of it had to do with the fact that it was this the court abused its discretion addressing certain things that happened either on pre-trial or during the trial. And if
Mhm.
y'all all remember on pre-trial, right, they were trying to change the venue. They wanted to change the venue and,
Right.
and actually ask for a new trial while on Ore Tene after everything was wrapped up. And then
Mhm.
so they were really pissed off by the fact that they had to be in Minneapolis where the crime occurred, right? Where the
Right.
offense occurred, where
Right.
the murder of George Floyd occurred. And they
Mhm.
want to get a where they want to go in. I mean, what
I'm
city would
sure
you
that
have
they want
gone in?
right. I'm everywhere in the country, everywhere in the world was familiar with the George Floyd trial. And so the idea that they weren't going to be able to seat 12 jurors independent who were capable of independently thinking about it. Because that's the reason why you would change venue, right? Is and this is the thing that we need to make clear. Even if you change venue, you still are using the jurors from the jurisdiction where the incident occurred. So even if they had the trial in Fargo. I don't know I don't know any other places in Minnesota outside of outside of Minneapolis and St. Paul, but I think Fargo's there. If but if that's where they if that's where they had it, then reality is you still would have been busing people from the Minnesota from the Hennepin County area into that city and still having them hear the case now. And the judge would have been the same judge if that's how they do it in Mississippi at least would have been presiding over the case. It just would have been presiding over the case in a different county. So the notion that they were going to get any fairer of a trial than they got in Minnesota is likely unrealistic when you consider the circumstances that they still are going to be presenting it before the the same pool of people. You know,
And let's be real here, though, man. You commit an offense like that in the community, I think that community should weigh in on what happens to that person,
yeah,
right?
absolutely.
And how we hold those people accountable. And so that's like saying, like, I don't know, like let's say some crime boss or mob boss that goes, you know what though, man, it was in New York City or it was in wherever or it was in Tulsa, I don't know, right? It was somewhere and he like, you know what though, dog? We want to have it in we want to have it in Louisiana, man. We feel like nobody knows about what happened, and so that's why we want to have it there. No, no, that's why we do need to have it in the venue in which the crime occurred because that's the
Right,
way juries work. Like, and then so part of the complaint is that look like the jury wasn't sequestered properly, which in other words they weren't admonished by the court to not to stay away from all media. And the thing about this, right, first of all, a lot of these a part of the filing and a lot of the arguments being made within the motion, the judge already like literally addressed almost every single portion of that outside of the jury's conduct on behalf of the brother who attended the March on Washington in DC, right? So outside of that, everything has already been addressed. And
right.
one thing that I want to just say that I just really find it, to me, this is why like media really actually gets underneath my skin a bit because they really didn't have anything to stand on. They knew that everything was already addressed, and they put this brother picture on the news, knowing the level of racial tension in this country, knowing
Right.
that 54% of the people in this country, right, racist, more likely racist folk, believe that Derek Chauvin acted reasonably under those circumstances, and any other officer would have acted the same. Although many officers, his peers in Minneapolis, Minnesota, came out and said that it would beyond the pale, right? The bail of actually what policy and procedure is actually
Right.
in the state of Minnesota, or in particular the city of Minneapolis. And so, like to me, it's like, bro, no matter how you slice it or dice it, people talking about like Derek Chauvin this, Derek Chauvin that, bro. Fact remains that you had your knee on this man's neck for 9 minutes and some odd seconds. So at the end of the day, unless that fact changes, I don't know how you get a different verdict.
Yeah. I mean, like literally the facts don't change. And I think what Yemi said is absolutely true. He said, let me take it like let me I'm put it back up on the screen. Yemi says who's a great attorney as well, trial attorney. So let me take a guess. They will search the past of all black jurors and demonize them for something as trivial as littering in 1999. And like so now, you're right, Yemi. Not only are they assassinating the victims' characters, they're assassinating the black jurors' character because they took the one black man that I know of. I mean, I think there was one black man on the jury. It was him, and they found a photo of him and said, "Oh, he's wearing a Black Lives Matter hat, or he's at a they call it a protest again. There was no protest taking. I mean, not in the sense that there was a civil discourse in the form of direct action at uh in the streets in Washington or anything like that. This man literally went to uh went to the March on Washington anniversary, which was already in place, and I want to say this um when did it happen? 19. Look, don't make me lie. I don't know what year it was, but this was the anniversary commemoration of March on Washington. and that was already planned, and that's why people were at the same location on that day for that purpose. And so, you know, I don't think that it's uh, too much for us to be worried about. I think that the news needed something to talk about, and I think it was important for us to give Black folks the peace of mind of knowing that this is the justice system has given us plenty of reasons to lack faith in it over the centuries that we've been here. But I don't think that this is one of those instances where we need to grip or clinch or uh, have a level of anxiety about this. So
That's
I'm
real.
glad that you put us on for this, brother. And yeah, I'm hoping that people will share it with their audiences, share it with their friends, let them know what we talked about in our analysis here, and yeah, continue to rock with Black with No Chaser.
All day, bro. And just remember, y'all just black with no chaser, dog. We think black and live black unapologetically, baby. 365, man. So y'all take care until next time, man.
Peace.